and International Arbitration. This lecture series has been organized by L.I.K.E, Legal Information, Knowledge and Expression, and Prudentia and Partners in association with International and Comparative Law, MLNU Aurangabad. Legitquest is the knowledge partner along with LegitEye as the media partner. Prudentia and Partners, founded in 2016, is one of the fastest growing law firms in Delhi, equipped with a very versatile team of attorneys dedicated to provide best services in a wide range of legal services across sectors such as civil, criminal, matrimonial, electricity, telecom, environmental banking, and commercial litigation. While also specializing in dispute resolution and intellectual property, having represented major corporations with major diverse business interests in India. L.I.K.E is an online one-stop solution for all the updates of the legal world with a goal to provide a platform to other budding brightest legal minds and ignite the culture of debate and deliberations across the fraternity. Maharashtra National Law University, Aurangabad is an institution established in the year 2017 with an objective of imparting quality legal education. Legitquest is an artificial intelligence-based legal research product. It is a state-of-the-art legal research platform for conducting legal research and is very well known for the introduction of the world's only one-click insight system called the iDraft Case Analytics. In short, the iDraft feature powered by artificial intelligence takes out the issue, facts, arguments, reasoning, and decision of a case law. Legitquest recently also has started with LegitEye, which is latest news, interviews, columns, and of judiciary. Now, today's topic is making of award, the content of arbitral award, the grounds for challenge, the grounds for appeal, and the enforcement of an arbitral award. I'm deeply honored to have Mr. Vikash Shukla as our esteemed speaker. He is one of the founding partners in Prudentia and Partners and is an experienced litigator for several years. His sphere of practice include the Supreme Court of India and several high courts, various tribunals such as TDSAT, APTIL, and DRAT. He's a seasoned lawyer in appellate forums for service, education, electricity, consumer disputes, civil, criminal, and arbitration cases. He specializes in emerging fields such as sports law, IBC, and labor reforms in the private sector. He has worked with Shri P.S. Narasimha, the then Additional Solicitor General of India, and assisted him in litigations of national importance and involving critical legal issues. He has also been an integral part of the mediation between the BCCI and various state cricket associations in implementing the reforms suggested by Justice Lodha Committee. In addition to the professional associations, he has represented clients like DMRC, Joy Lucas Private Limited, JK Cements, Videocon Group, and several distinguished citizens of the country. So our today's session will be for 45 minutes, followed by a Q&A. I would request all our participants to be on mute and without video throughout the call. And all questions to the speaker can be written in the chat box, which will be taken up at the end of the session if the time permits. I would now hand over it to Mr. Shukla. Sir, please.
Thank you so much for the introduction, Tulip. Am I audible now?
Yes, sir, you are.
Yeah, thank you. So today's topic, we've actually tried to cover a lot into it. And I am the one who will be taking tomorrow's session as well. So if something is left today, we'll continue tomorrow. I intend to basically cover 4 things today: the making of the award, the content of the arbitral award, the grounds of challenge, and the grounds of appeal, if any. So we've been, because this is today, I believe, the 7th session. And the first 6 sessions, we've already seen the fundamentals relating to the arbitration law in this country. And we've seen how important it is to draft a good arbitration agreement, and what are the anomalies which arise if the arbitration agreement is not drafted well. So most of these topics, as we will see today, are interconnected. So when we talk of the award, or when we talk of the grounds of challenging that award or the appeal, they're all interrelated. The most important thing when it comes to the making of award is this starts with Chapter 6 of the Arbitration Act with Section 28, which talks of rules applicable to substance of dispute. You will see that when the moment a reference has been made and a tribunal or an arbitral tribunal has been appointed, the first and the foremost difficulty, or the first and the foremost issue with which the arbitral tribunal or any arbitrator is held is as to the choice of laws. Choice of laws would mean which laws would be applicable for the proceedings of the arbitration. These laws may be at different levels, can be categorized in 4 different forms, as you can see on the screen. One would be the substantive law applicable to the merits of the case. The second would be the substantive law applicable to the arbitration agreement. And the third would be the procedural law applicable to the arbitration proceedings. And fourth becomes relevant only in international commercial arbitrations, which is the rules applicable to determine each of the arbitration, each of the laws mentioned above. These basically deal with the conflict of laws issues, which are generally under the aegis of the private international law. So when we talk of domestic law, the fourth category may not be very important. But the moment we start discussing international commercial arbitration, the fourth category also becomes relevant. So the first and foremost thing is that we will have to understand the distinction between the substantive law and the procedural law. Because here you will see in the first 3 categories, the 2 foremost are the substantive law and the third is the procedural law. So the substantive law, the Black's Law Dictionary, is the law according to which the rights and liabilities of the parties can be decided. So for example, in India, if you will see, the law of contract is substantive law. Or for example, transfer of property is substantive law. But at the same time, CPC or the Evidence Act is procedural law. Evidence Act cannot strictly be called as procedural law, but most of it is procedural law. So substantive law is the law which talks of the rights and liabilities and obligations of the parties, and procedural law is the law which defines the medium through which those rights and liabilities can be established. So moving ahead, the first thing which I wanted to discuss is this Reliance Industries Limited and another versus Union of India. Why this case is important is this actually shows how important the application of laws is essential to this issue. What happened in this case is that both the parties were Indian. The contract was to be performed in India, but the seat and the law which was to be applicable, that was to be of London. So the parties had agreed that the contract law shall be governed and interpreted in according with the Indian laws, but the seat of arbitration was London or Paris. So 2 options were given, either London or Paris. So upon dispute, the parties then partially agreed that the seat of arbitration would be London. Now this and a partial award was also framed in this regard after when the parties had agreed. This itself was challenged in Section 34 before the Delhi High Court, and the Delhi High Court said that it will be against the fundamental laws of the country.
Sorry for the interruption, sir. There is some disturbance going on from your end, actually. There must be some network disturbance or something.
Okay, let me just check. Give me a moment.
Yeah.
I don't see any network glitch from my end. Am I audible now?
Yeah, it is clear now, but in between there was some disturbance coming. In case it comes again, I'll inform.
Oh, thank you so much. Thank you so much.
Okay.
So here, what happened is that, just give me a moment. Yeah. So as I've already discussed that both the parties were Indian and they had decided that the contract shall be governed and interpreted in accordance with the laws of India. But the seat of arbitration was London. So the parties, because in the arbitration agreement, there were 2 options given, London or Paris. So the parties agreed that the seat of arbitration would be London. So in terms of the agreement of the parties, the partial award was passed, which said that the seat of arbitration would be London. Now, this itself was challenged before the Delhi High Court in the Section 34 proceedings, stating that if the substantive laws of London would be applicable, or the English contract law is made applicable, that would be detrimental to the fundamental laws and policies of this country. And the High Court in that Section 34 allowed it, stating that the question of arbitrability of dispute is not a pure question of pure question of law of arbitration or lex arbitrary, but a larger one governing the public policy. Now, when the matter came to the Supreme Court set aside the judgment of the High Court, stating that the conclusion that if the award is sought to be enforced outside India, then it would leave the Indian party remediless is without any basis. As the parties have consensually agreed that the arbitration will be governed by the English law, so then thereafter they cannot come and challenge this before the Indian court, saying that the substantive law cannot be the English law. So the Supreme Court then explained that if the parties have agreed as to what will be the laws governing and what would be the seat of arbitration, then the court should not interfere. Recently, just a couple of days back, on 24th of November 2020, in a similar case, the Delhi High Court has ruled again in the same manner. In this case, what happened is that two Indian parties, they agreed, one party agreed to supply American cotton to the other party. But the arbitration agreement said that the seat of arbitration would be London, and the laws applying here also would be English laws. So when the arbitration was invoked, one party filed a suit here before the Delhi High Court, saying that this invocation of arbitration is bad because the parties are here and the contract has been performed here. And the Delhi High Court, relying on the Reliance Industries, which we just referred, said that no, this position has been settled. If the parties have consensually agreed as to what will be the seat of arbitration, which law would apply substantially, then the parties cannot take back that situation. Those of you who are further interested on this issue should read a very recent judgment of the English High Court. It's called Chubb Russia. So in this case, what happened is that the two Russian companies, Chubb Russia is an insurance company basically. So what happened is that between two Russian companies, there was an arbitration agreement which said that the seat of arbitration would be London. So there emerged a fire in the plant of one of the company, and it filed a tort claim in a Russian court. So the second party initially participated in the proceedings at the notice stage, and after a delay of 18 months, filed an anti-suit injunction in a court in London, saying that the court should injunct the other party to proceed in Russia because tort is not arbitrable as per English laws. Now, the issue here was, when the English High Court was hearing this case, the English High Court had to decide basically two things as to which is the law in substance which would apply, whether the parties have agreed on that aspect or not. When it looked at the arbitration agreement, the English High Court said that the parties have not agreed as to which law will apply. Therefore, the English High Court said that because the parties have not agreed as to which law will apply, so therefore we will not decide this issue right now. Secondly,
for the interruption, sir, again, there's again some disturbance coming. The voice is cracking as well.
See, there's no problem at my end so far as the internet is concerned. Am I audible now?
Because we want to log again. Even I'm facing some type of disturbance.
Should I log in again?
Just a second, sir. Yeah, you can.
Discussing actually the Chubb Russia. So what happened that the English court said that one, that the parties have not agreed as to which law will substantially decide the disputes. Two, that one party had initially participated in the proceedings before the Russian courts, and after a delay of 18 months have come to us seeking an anti-suit injunction. So the English courts denied it on two grounds. One, saying that you ought to have invoked the arbitration initially, and two, because it is yet not settled as to which law will apply, hence we will not grant anti-suit injunction. The problem here was that in terms of English law, even torts are arbitrable. But in terms of Russian law, torts are not arbitrable. So if Russian laws were to apply, then even if the English courts were the supervisory courts, they could not have granted the anti-suit injunction because it was beyond the purview of arbitration. But if English law was to apply, then they could have granted anti-suit injunction. But in the instant case, they said that because the arbitration itself has not been invoked and this decision has yet not been taken as to which law will apply, so they denied to grant the anti-suit injunction. Now, thereafter, after section 28, which we've discussed as to which law will apply, which substantive law will apply, section 29 of the Act, talks about the decision making by the panel of arbitrators. Now, in this section, you will see that it categorically says that unless otherwise agreed by the parties in arbitral proceedings with more than one arbitrator, any decision by the arbitral tribunal shall be made by a majority of all its members. Now, this is very interesting because you see, if it is a sole arbitrator, then there is no problem. But if it is more than one arbitrator, or there are three arbitrators, where one of the parties has given one arbitrator and the other party has given one arbitrator, and there's a presiding arbitrator. So it may so happen that an arbitrator who has been appointed by party B may decline to sign the award if he sees that the award is going against party B. So it is only to cure such kind of defects that section 29 very categorically states that any arbitral tribunal's award, a majority award, will be considered a legal award. So even if one party has not signed, that does not matter. Just that there's a clarification in clause 2 which categorically states that if one of the members in the arbitral tribunal has not signed the award, then reasons should be specified as to what is the reason for which the member did not sign the award. Moving ahead, section 29A, which has been brought in as an amendment after 2015, brings the arbitration in a time frame manner. So what does section 29A does is, it says that all arbitration from the date of the appointment of the arbitral tribunal, or from the date when the tribunal has been constituted, the arbitration shall be conducted within 12 months from that date. So it actually, see, the whole object of arbitration, as we've been saying from the very beginning, is to give a quick remedy, because in litigation a lot of time is taken. But with the experience in Indian arbitration, the parliament realized that even arbitrations are taking a lot of time because of certain problems like the change of arbitrator or the parties delaying the proceedings. So now they have brought it, they said that the arbitration has to be conducted within 12 months. Now, if the arbitration cannot be conducted within 12 months, one of the parties is free to approach a court seeking extension. During that extension, the constitution of the tribunal will not be termed as terminated. But as soon as the High Court grants that extension or denies that extension, the fate will be made. So this has been brought to stipulate the whole arbitration in a time-bound manner. Another amendment is 29B, which talks about fast-track procedure. Now, in the fast-track procedure, what it says is that the arbitration has to be conducted within 6 months. Now, it also gives power to the arbitral tribunal and the parties that if they so wish, then the arbitration can be done orally. I mean, without getting into the oral evidence, only based on the pleadings which have been given by the parties, like the statement of claim or the statement of defense, the arbitration can be concluded. However, even in this, the extension which we've seen in 29A, that procedure is applicable. So if the fast track tribunal also cannot complete the arbitration within 6 months, then parties can apply for extension, and accordingly whatever provisions are mentioned in 29A from subclause clause 9 will again become applicable in 29B. Now, thereafter, you will see that section 30 talks about settlement. So there's a specific session which we'll do, which is the last session on conciliation. In that, in section 30, in detail discussion will happen. But as of now, I should tell you that even during the arbitral proceedings, if the arbitral tribunal thinks that the parties can come to a settlement by way of a mediation or conciliation, they are very well free to refer them. And if the parties themselves agree that there can a settlement which can be reached between the parties, then also the tribunal and the parties have full freedom to go and settle the matter by way of a mediation and conciliation. The only precaution which they have to take is that pursuant to that settlement by way of mediation or conciliation, they will have to come back to the tribunal, and the tribunal will have to convert that settlement into an award. So unless the tribunal or the members of the tribunals have signed that settlement, that will not be considered as an award. So there may be a problem at the stage of execution. So even if the parties have settled by way of mediation or conciliation, they will have to go back to the tribunal for the finality of the tribunal arbitral proceedings. Now, thereafter, we come to the form and content of the award. As we've been discussing from the very beginning, the form and content of the award, whatever has been mentioned in chapter 5 and in section 7 and 8, if you combine all that together, you will get what is the requirement of this section. So it says that the award shall be made in writing and signed by the members. Award shall state reasons unless parties have agreed that no reasons are to be given, or award is upon agreed terms as mentioned in section 30, which is for settlement. Award shall state the date and place of arbitration. It is very important because the place of arbitration and date is important, because the place of arbitration also helps in deciding the law applicable to the arbitral proceedings. Now, this section also says that during the arbitral proceedings, if the arbitral tribunal thinks fit, or if it is the necessity, then it can also pass an interim award. That interim award will subsequently become a part of the final award, but to avoid any kind of inconvenience to the party, and if it is very important and the facts and circumstances are such that if an interim award is not passed, then one party may be at some kind of inconvenience or may suffer some irreparable loss, then they can pass an interim award also. In the last subsection of this section also talks about interest. So there's been an amendment which is very what happened initially is that generally in awards 18%, 20%, but the parties have, but the amendment has now been made, which categorically states that at the most the arbitral tribunal or any arbitrator can give 2% more than the prevalent or current rate of interest. Now, the current rate of interest, it has been explained in the amendment, would be in terms of the Interest Act. So the previous practice of awarding 18% and 22% along with the award has been done away with. So the intention of the parliament was to bring in some balance so far as the interest part is concerned. So the parliament has made it very clear that while passing the award, now the arbitral tribunal or the arbitrator can grant interest only 2% more than the current rate of interest, which is prevalent. Thereafter, section 32 is important. So section 32 talks about the termination of the proceedings. Now, the termination of proceedings can happen upon passing of the final award. So let's say the arbitral tribunal has pass the final award, then the mandate of the arbitral tribunal has finished and its job is over. So that will be terminated. The second would be when the claimant withdraws the claim. Let's say the claim. Then also the arbitration will come to an end and will be terminated, subject to any objection by the defendant. And if the arbitrator thinks that the objection of the defendant is right, and if the claim would not be heard, then the defendant may suffer certain losses because of this proceedings, then the arbitrator may continue. Third is that if the parties themselves, they agree upon the termination, then also it may happen. And if the tribunal finds that the continuation has become unnecessary or impossible for any reason, then also the arbitration proceedings can be terminated. Section 33 talks about correction and interpretation of award. Now, this is very important. What happens is that once the award is passed, the other remedies which are available under the Act come into play. Remedies which are given under Section 34, 37, or 35 and 36. Either you challenge the award, or if the award is not challenged, the other party will go for enforcement. So before that happens, why 33 is important is 33 talks about certain computation errors, clerical errors, typographical errors. So if one of the parties, after reading the award, realizes that this is nothing but a clerical error or a computational error, it may within 30 days of the passing of the award, file an application before the tribunal and say, after due notice to the other party, and say that this was a computational or clerical error, kindly correct it. And then the arbitrator has to just check whether the other party has been notified. After calling both the parties, the arbitrator may correct that. Now, there's one more ground on which this section can be invoked. That ground is that if one of the parties realized that there were, let's say, 6 claims raised before the arbitral tribunal. Out of the 6 claims, the arbitral tribunal has given its finding only on 5 claims, and in terms of one claim, the arbitral tribunal has not given any findings. That means it has not considered it. Then also an application under this section can be filed, and the party may bring it to the notice of the tribunal or the arbitrator that this was a claim raised, documents were submitted in this regard, arguments were made in this regard, but despite that fact, the arbitral tribunal has not considered this claim. After due notice to the other party, the tribunal, if it deems fit, may change the award accordingly within 60 days. It may take some more time, but not more than 90 days in all. So now this chapter is finished so far as the content of arbitral award and how the arbitral award is made. Now the next chapter is very important, which is recourse against the arbitral award. In this chapter, we will basically today look at section 34, which is the grounds on which an arbitral award can be challenged. Now, section 34 is the most important section so far as challenge to arbitral award is concerned, because there are only 2 sections according to which the arbitral award can be challenged at 2 levels. First is 34, second is 37. 37 is nothing but an appealable order against an order which is passed under 34. So the main grounds to challenge any award are nothing but section 34. So let's read section 34 first, and then we will go on to see the case laws as to how the Supreme Court has in the last 25 years interpreted this whole section 34. So 34 says, application for setting aside arbitral award. Clause 1 says, recourse to a court against an arbitral award may be made only by an application for setting aside such an award in accordance with subsection 2 and subsection 3. Subsection 2 talks about an arbitral award may be set aside by the court only if A, the party making the application furnishes proof that 1, a party was under some incapacity. So if the parties can show that they were under some incapacity. 2, the arbitration agreement is not valid under the law to which the parties have subjected it. Or failing any indication thereon under the law for the time being in force. So if the parties may show that the award was passed under a law in which it ought not have been passed. Third, the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present his case. So this is nothing but what we've already discussed under section 18, equality of treatment between the parties. So if there's a violation of the principles of natural justice, that if one of the parties or if the formation of the arbitral tribunal was not notified, or the proceedings before the arbitral tribunal were not notified well in advance, then also the award can be challenged. Fourth ground is the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration. So this fourth point is very important. This actually gets into the merit of the issue. It says if something was decided by the arbitrator which was beyond the terms of the contract, then also the award can be challenged. There is a proviso added to this, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted, only that part of the arbitral award which contains decision on matters not submitted to arbitration may be set aside. So this, again, the proviso gives we may call it doctrine of separation. It says that if an award has been passed, the contents of which can be further subdivided in two categories. One, claims which were submitted to the arbitral tribunal and were well within the terms of the contract. Second category would be either the claims which were not submitted to the tribunal or the claims which are beyond the terms of the contract. Then if possible, the award can be segregated in these two, and only that part of the award which was beyond the terms of the contract or the claims which were not submitted to the arbitrator can be set aside. Fifth, says the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties unless such agreement was in conflict with the provision of this part from which the parties cannot derogate, or failing such agreement was not in accordance with this part. So this we will actually from here onwards and clause B onwards, you will see that the whole problem arises where we will see one by one as in terms of the case laws how courts have decided. B of this section says the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force, or the arbitral award is in conflict with the public policy of India. This word public policy, let's remember for a moment. This will have a huge role in this section as we will see the interpretation by the courts. This public policy was for the first 15 years interpreted in a very wide way, and then the Supreme Court tried to narrow it down, and then an amendment came which has further narrowed it down. So we will get into those one by one. Now, there's been an explanation added to this by 2015 amendment, which says for the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if the making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or section 81, or it is in contravention with the fundamental policy of Indian law, or it is in conflict with the basic notions of morality or justice. So section 75 and 81 is nothing, but there are certain confidentiality clauses mentioned in section 75. It says that the arbitral tribunal and the parties amongst each other should respect the confidentiality, and they should not disclose certain informations which ought to have been confidential. And 81 talks about all those admissions or suggestions made during mediation or conciliation proceedings, if any there were, then those admissions cannot be brought before the arbitral tribunal during the arbitral proceedings. So these two things are mentioned, that if there's a breach of a confidentiality clause, or if one of the parties has tried to bring statements which were made during admission happened during the mediation or conciliation, those admissions or statements cannot be relied upon before an arbitral tribunal. And if these two things happen, that also be considered as a breach of public policy. Now there's an explanation too, which says, for the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. With this, we will get into the case laws. There's an amendment in section 34, which is 2A, 2 capital A has been added. But I want to get back to it after we've dealt with a couple of cases, because then we will get a proper perspective of these things. So the first case in this is the ONGC Limited versus Saw Pipes Limited 2003 5 SCC 705. Now in this case, what happened is that ONGC had allotted certain works to a contractor for a project for performance. Now the contractor delayed the execution of the work. Now once the contractor delayed the execution of the work, ONGC of course sought liquidated damages. So when the liquidated damages were not paid, then the ONGC initiated arbitration proceedings. During the arbitration proceedings, when the award was passed, the arbitrator denied those liquidated damages. When this matter reached the Supreme Court said that the denial of damages was contrary to the terms of the contract, and therefore the Supreme Court looked at the contract first. And in the contract, it said that there was a clause which said that if there will be some delay, then liquidated damages will be paid. And the Supreme Court said that because the arbitrator has not followed this part of the contract, and that is why there's a problem. In 1995-96, in Renu Sagar, the Supreme Court, during while enforcing a foreign award, had actually looked into as to what would be the public policy doctrine in India. And in that, it had very categorically said that there will be three tests. They would be that if the fundamental policy of India is in some way disturbed, or the interests of India, or there's a problem in justice or morality. These were the three tests of public policy, so far as Renu Sagar is concerned. But in ONGC Saw Pipes, the Supreme Court added a fourth angle and said that if the arbitrator would not look into the contract or the terms of the contract, and while passing the award, if it so comes to light to the court that the terms of the contract have not been looked into, then that itself will be a ground to challenging the award, and the Supreme Court named it patent illegality. And then the Supreme Court in ONGC Limited versus Saw Pipes defined what would be patent illegality. The Supreme Court said that patent illegality would mean when the award was in breach of the substantive provisions of any law, be it the contract law, constitutional law, or any other law in India, or if it is in violation of any of the provisions of the Arbitration Act. So the first ground would be that if there is a breach or violation of a substantive provision of any law in India. Second would be any provision of the Arbitration Act if it is violated. The third, they said, which was under the Saw Pipes category, they said the terms of contract in question between the parties have not been followed. So if any one of these three ingredients is found, the Supreme Court said it will be considered patent illegality. Now the problem with this case was that, as we've already seen, Section 5 of the Arbitration Act very categorically talks about limited judicial intervention. Why it is so is that arbitration itself has to be a speedy remedy. So it has been mandated that judicial intervention in terms of Section 5 of the Arbitration Act can happen only as provided under the Act. And the Act categorically, as we have seen under Section 34, one by one mentions all the criteria on which an award can be said to be bad. Now the Supreme Court saying that if the arbitrator has not looked into the terms of the contract, that itself was there in 34. It could have simply said that the award is bad because the terms of the contract have not been followed. But the Supreme Court, by adding one more criteria to the public policy, which is patent illegality, actually opened Pandora's box. So then after 2003, we will see that the Supreme Court time and again set aside the award, send it back to the arbitrator. So imagine how much time being spent in an arbitration, then section 34 proceedings, 37 proceedings, and when the matter goes to Supreme Court says patent illegality, go back, initiate the arbitration proceedings afresh. So that would mean that it has become lengthier than the normal court proceedings for the parties. So the whole idea and object of the Arbitration Act got defeated because of this thing. Now, the Supreme Court in 2014 went a step ahead. In between, what happened? That the Parliament realized that there's a problem, that the Supreme Court is setting aside the award, sending it back, and because of which the parties are facing difficulties. And the whole idea of bringing the Arbitration Act in terms of the model law has actually become futile. So the Law Commission gave its report, the 246th Law Commission report, which is very important. We all should read it. The Law Commission realized this difficulty. It actually referred ONGC versus Saw Pipes, which we see the 2003 judgment. And it said that the Supreme Court has actually widened the scope of Section 34 by bringing this patent illegality aspect of it. While the Law Commission report was pending and the Parliament was yet to take action, in 2014, in another ONGC case, ONGC Limited versus Western Jaco International Limited, this is 2014 9 SCC 236, 263. The Supreme Court went a step ahead. Now what it did is, in this case, what had happened is that ONGC had deducted the payments owing to the delay due to the contractor. Now, in the previous case, they had asked for liquidated damages because of the delay. In this case, what they did is they deducted the payment from which was supposed they were supposed to make to the contractor. And this thing, what happened is that when the arbitration proceedings initiated, in the award actually set aside the whole deduction, however, allowed partial deduction to a very limited extent. Now, when the matter reached to the Supreme Court went a step ahead and divided the whole period into 4 segments. It said that you cannot directly say whether there was delay or not. Supreme Court assigned reasons to those delays and divided the whole delay into 4 segments, and then said that so far as 2 segments is concerned, the tribunal was correct. But for the other 2 segments, it was not correct, and hence sent it back. Apart from the patent illegality, the Supreme Court now added one more criteria to it, which said that beyond saw pipes, the grounds of fundamental policy of Indian law will also include 3 juristic principles. Now, what were these juristic principles? The Supreme Court said the first of these juristic principles would be judicial approach. The second would be natural justice. And the third would be perversity. In the judicial approach, they said that award should not be arbitrary, capricious, or whimsical. In the natural justice approach, it said that it should follow Chapter 5 guidelines, which are given in the Act. That means natural justice and audi alterum partem and all these things. The last, perversity, the Supreme Court said that there should be no perversity or irrationality or lack of reasonableness. So it said that if you look at the interpretation which is being given by the arbitrator, and if you find that that interpretation itself is perverse, that it is not possible, then also the award can go back. So saw pipes was not less. Another Western Jaco International was added by the Supreme Court, widening the scope of Section 34 proceedings. Then came 2015 3 SCC 49, which we call as Associate Builders versus DDA. So this judgment is actually an excellent judgment. It came immediately before the amendment, but the foresightedness of Justice Nariman, hats off to his foresightedness, he actually interpreted 34 in such a way that when the Parliament brought an amendment in terms of the Law Commission's report, Associate Builder till date is still a good law, even after the amendment. Look at the beauty. So what he tried to do is that the saw pipe was a 3-judge bench and Associate Builder was a 2-judge bench. So even if Justice Nariman wanted, he could not have overruled saw pipes. But what he did brilliantly is he read saw pipes, he read Western GECO, and he tried to harmoniously construct them and said that public policy, the way it has been widened in saw pipes and Western GECO, is not the correct way of reading those judgments. The correct way of reading those judgments would be in terms of the letters of Section 34. So if you read the letters of Section 34, it becomes very clear that so far as the fact is concerned, arbitrator is the final authority. So if the Justice Nariman went a step ahead, he said that not only the possible view, even if the plausible view is not there and a possible view has been taken by the arbitrator, then also courts will not interfere. So the Supreme Court here got a chance to close the Pandora's box, which was opened by saw pipes and Western GECO, and held that the arbitrator is the final word on the facts unless prima facie perverse or unfair findings can be shown. The court categorically stated that the construction of the terms of the contract is primarily for an arbitrator to decide. So in any 34 proceedings or 37 proceedings, the court will not hereafter interfere. So associate builders tried to harmony was brought. Now we'll come back to the Bare Act and we will see as to what 2A has been added. So section 2A to section 34 says an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award, provided that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. So here, this amendment has actually brought and clarified that even if the arbitrator has applied the law erroneously, then also courts will have very limited jurisdiction. So it's not only as to the interpretation of the contract. Associate Builder clarified one thing, that if there are two possible views or plausible views and the arbitrator has handpicked one, then the courts will not interfere. The arbitrator is the final authority so far as the interpretation of the contract is concerned, so far as the fact finding is concerned, because it is the arbitrator before whom all the witnesses had deposed, all the evidence and documentary evidence has been submitted. It is the arbitrator who had heard the matter at length. So fact finding, so far as fact finding is concerned, arbitrator is final. And Associate Builders further distinguished 34 from a normal appellate authority. It said that 34 should not be construed as an appeal to an award. Rather, it is just the normal principle that a judicial review or a review or a final checking by a court should happen. That's why 34 as a matter of abundant caution has been given. It's not as if the court will sit in appeal and see whether the appreciation of evidence has been done in the right way or not. All that the court has to see is that whether the proceedings were done in a very fair manner, whether the parties were given opportunities to argue, whether the arbitrator has considered all the pleadings and evidence which was brought before him. And if all these questions are answered in affirmative, then 34 is over. So the only additional thing which Associate Builder says is that if there is an interpretation which evidently is unreasonable, and the touchstone of that, he said, is Wednesbury principle of reasonableness. He said that we will just check the reasonability of that interpretation, and if we find that it is reasonable, then we will not interfere, even if there are any other interpretation possible or more plausible interpretation possible or whatever it is. Now, after the amendment, when the amendment has further curtailed, all that the parliament tried to do is that the scope and extent of 34 was expanding. because of saw pipes and Western JECO. So the Parliament in 2015, it was in such hurry after the JECO judgment was passed by the Supreme Court that it brought the amendment by way of an ordinance first when the Parliament was not in session, because the Supreme Court, the Parliament realized that if the over-expanding ambit of Section 34 is not stopped, then the parties will suffer. So by way of ordinance, what they did is they curtailed what the Supreme Court in saw pipes and Western JECO had said, and it brought down categorically and said that whatever criteria are mentioned in 34, that should be the final criteria. The only difficulty which the parties were facing is that the Supreme Court was interpreting the word public policy in a very wide manner. So by way of this amendment, they brought two explanations to Section 34, by which the word public policy also has been curtailed down to only 3, as we have already seen. That if it was seen that it is the award has been passed by some fraud or by violation of Section 75 and 81, that's one. Second, if it is in contravention of the fundamental policy of Indian law. Third, if it is in conflict with the most basic notions of morality or justice. Only on these 3 grounds, public policy doctrine will be invoked so far as 34 is concerned. Now, after the amendment, there are 4 more important judgments which I would discuss, because we have a scarcity of time. One is very important, which is Xiangyong. Xiangyong is also Justice Nariman's judgment, and Xiangyong is important for 2 reasons. One, that it is post-amendment, it actually settles the law, because when Justice Nariman had passed associate builders, then 34 was not amended. But when Xiangyong came before him, then amendment had come. So he got an opportunity to fortify associate builders. So he did nothing else except explained associate builders and supported it, that the Law Commission report and the amendment has done nothing but what he had done in associate builders. So he fortified that law. But on the facts of the case, a very interesting thing happened in Xiangyong. What happened is that Xiangyong is a Korean company which had entered into an agreement with NHAI for the construction of a 6-lane road on NH26. Now, what happened when the agreement was made, the tariff of the government NHAI was fixed. Now, during the encashment of the contract, when the contract was in existence, then the tariff changed. And when the dispute arose, when the matter was referred before the arbitral tribunal, there were 3 members in the tribunal. One of the issues raised by Xiangyong was that because this tariff has been changed after we had already entered into the contract, so now today, if you read the new tariff, then you are doing nothing but remaking the contract, which is not possible under the Indian arbitration laws. But the arbitrators, they decided, and 2 arbitrators held in favor of NHAI, and 1 arbitrator wrote a dissenting opinion accepting the arguments which were given by Xiangyong. When the matter reached before the Supreme Court, Justice Nariman, again harmonizing saw pipes and Western JECO and looking at the amendments, the Law Commission report, the associate builders, he held that what I had said in associate builders is fine. That whatever has been decided by the arbitrator so far as interpretation is concerned is the final word. But in the facts of this case, he said that because the tariff came into existence after the parties had entered into the contract, so relying on that tariff was a patent illegality. He said that. But then he said that now if we send it back again to arbitration, if we set aside the award and we send it back to the arbitration again, then a lot of time will be wasted. And therefore he said that this dissenting award passed by the single member, which is the correct interpretation of the contract, is the right award. And he upheld the dissenting award using his 142 discretion, Article 142 of the Constitution. Now the only difficulty is that the moment we are discussing the jurisdiction of 34 or 37, which generally comes before High Court, and the High Courts do not have jurisdiction such as 142 of the Supreme Court, then even in Xiangyong, the award would have been set aside and sent it back to High Court. Had it not been Justice Nariman deciding this matter in 136, and if he was deciding in under section 34, then he also had no other remedy except to set aside the award and send it back to the arbitral tribunal to decide it all afresh. So that's so far as Xiangyong is concerned. Other three cases, as we discussed post-amendment, we picked up 4 cases. One is Xiangyong. The second is MMTC versus Vedanta. In MMTC versus Vedanta, interestingly, what happened is that there was an agreement made between MMTC and Vedanta's predecessor. So the agreement said that MMTC will take goods from Vedanta and will supply to its own clients. In effect, what happened, in practice, what happened, that a particular client of Vedanta, which is HPPTL, Vedanta requested MMTC to grant those goods to HPTTL, and MMTC accordingly granted. Now, when the commission of those goods which were given to the Vedanta's clients came, the dispute arose. And when the dispute arose, arbitration was referred, award was made, and award was made in favor of Vedanta. 34 was filed dismissed, 37 was filed dismissed. When it reached the Supreme Court here then upheld what has been held in Associate Builders and said that the arbitrator has decided that the terms of the agreement were such that you will pick the client and you will deliver the goods, and then we will not interfere in the arbitrator's award. Third is Jharkhand versus HSS Integrated. Jharkhand versus HSS Integrated and Dyna Technologies Private Limited. In Dyna Technologies Private Limited versus Crompton Greaves, Justice Ramana has given a very interesting judgment like your Xiangyong. What Justice Ramana did in this case, this was a long pending dispute between the parties. The arbitration was invoked in 2001 and the matter reached the Supreme Court in 2019. So Justice Ramana, when he looked at the award, he said that the award is perverse, that the finding of the award, they are not correct. But because so much time has been spent, so if I set aside today and send it back the award, again parties will have to go back the whole process. So instead of setting aside the award and sending it back to the arbitrators, Justice Ramana gave a lump sum amount which the other party was asking, again under his 142 supervisory jurisdiction. So this again shows that in effect, even if the law which has been amended, even if that law is applied, then also at times awards are so perverse, the interpretation of contracts or the interpretation of the terms of the contracts are so perverse that the courts are left with no other remedy but to set it aside. So despite the fact that section 5 stands, which talks about least judicial intervention, despite the fact that section 34 very categorically gives point by point grounds on which the awards can be challenged, still it so happens that when the matter reaches the finality before the highest court of the country, the courts are left with no other remedy except to set it aside and say you go back and decide it afresh. So that's the difficulty. But the amendment which has been done in 2015, that has to an extent tried to resolve the matter in a way, because it has now narrowed the scope and extent of 34, which was widened and broadened by the Supreme Court in Saw Pipes and Western GCO. Now, the only thing which in today's topics, as we had discussed, is left is enforcement of domestic awards. That I intend to cover in my tomorrow's session when we'll be talking about foreign award and enforcement of foreign awards. Thank you so much.
Thank you, sir. Thanks a lot. That was really helpful. Now we have some questions with us. I'll just put. We have covered most of them, but we can skip the ones that we have covered. First one is, can the enforcing court stay the enforcement proceedings, outcome of proceedings to set aside the award at the seat of arbitration? If so, will the court order the party seeking the stay to provide security?
See, I would just say that I will cover this question tomorrow when I actually discuss the enforcement of awards. Then it'll be in the context.
Okay. The second question is, does our domestic arbitration legislation, case law, or the rules of domestic arbitration provide for the enforcement of orders by emergency arbitrators?
See, the emergency, there's a specific provision for fast track arbitration, please understand. So whether it is a fast track arbitration or a normal arbitration, it will lead to an award. Once the award is passed, the normal enforcement proceedings will apply. So even if it is an emergency arbitration or a fast track arbitration, enforcement cannot happen before a final award is passed. So if an award is passed, enforcement will happen.
Okay, sir. The third is, what are the stamping and registration requirements of domestic awards?
See, those are in the rules, but yes, awards need to be stamped, and before delivering to the parties, the arbitrators needs the awards to be passed on the stamps. Those are in those statutes itself.
Okay. The last question we have is that on 4th November 2020, the Government of India has issued the Arbitration and Conciliation Amendment Ordinance 2020.
All right.
What are your thoughts on that, which has introduced unconditional? Yeah.
I will have to check it, and I will answer this question tomorrow because I have still not seen that amendment yet.
We have received one question right here. It says that whether an award under Section 30 settlement is subject to challenge under Section 34 of the Act.
See, section 30, the only difficulty would be that parties have mutually agreed. Please understand that this is the whole process of arbitration is such that if you look at international commercial arbitration, there are even provisions in Redfern, Hunter, and Dicey, and Morris, and all these writers, they've discussed about uh, equity arbitrations, where the parties decide that there'll be no substantial law governing the arbitration. And they, amongst themselves, they decide that the arbitrator can decide the dispute based on equity. And if so happen, if let's say if the parties have agreed to adjudicate the matter based on equity without application of any substantial law, then on what grounds it will be challenged? So section 30, because it will be a settlement between the parties, then I don't think, see, if 30 is also open to litigation, then settlement will never be reached. Because in 30, if you read carefully, it is not somebody who has forced you to enter into a settlement. The parties, they sit, they discuss their rights and obligations. Having discussed their rights and obligations, they go back to the arbitral tribunal and say that we have reached the settlement, and therefore the arbitral tribunal passes an award. So that will not be open for challenge. But
Thanks a lot.
There can still be certain exceptions where if it can be shown that the award is bad in terms of law, or there's some perversity in the award, but the scope of challenge so far as section 30 is concerned will be very limited.
Okay, sir, thanks a lot for that. That was really helpful and insightful, and thank you for exceptional, insightful views. And we appreciate you being here with us. And thank you to the attendees also, and we hope to see you tomorrow as well for tomorrow's session. Thank you so much, sir.
Thank you. Thank you.